Appeals to order. Just before we get started, I'd like to ask everyone that's online on the meeting if you could mute your microphone when not speaking. I'll give people plenty of time to speak up for the public participation. Just it keeps the background noise down for the people that are speaking. So the first thing on our agenda is a new hearing for Birch Street. Jim, could you read that into the record for us, please?
Sure. Petition for James Danaher for property located at 0 Birch Street, Locust, book page number 16280-79, map number 31, parcel number 53-0. The applicant is seeking an administrative appeal of the building inspector's revised opinion letter dated September 30th, 2020, stating after review of additional information, he has determined the mentioned parcel is not a buildable lot. The applicant is seeking to have a decision reversed. Documentation in support of this proposal is available for public inspection as shown on plans filed with the Zoning Board of Appeals, and a copy is on the file of the town's clerk office or on the Board of Appeals permitting system number 20.
Okay, thank you, Jim. Is the applicant online?
I am, Mr. Chairman. Thomas Murphy here for James Danaher. Just a couple of housekeeping things, if I could quickly, Mr. Chairman. First of all, this is for Joe Ellen. I'm in the habit of bringing the green cards to the meeting and giving them to her that evening. I realized this afternoon that there is no meeting to go to, so I'll drop the green cards at the town hall.
That will be fine.
Thank you. And the second one, Mr. Chair, just to clarify, this property has been identified in some places as 0 Birch Street. This is actually a vacant lot. It has no street number assigned to it. I don't know how it came up with the moniker of 0 Birch Street. My guess is somewhere along the line, because it was a lot with no number, somebody just put 0 on it. But there is a property on Birch Street numbered 0 Birch Street. And I've talked to the homeowner, and he's just concerned that there might be some confusion that this petition somehow refers to his property, and it does not, obviously. So I apologize for that confusion. The lot is properly identified in the notice under its map and parcel number, but it should not be called 0 Birch Street. I've just been referring to it as the Birch Street lot. But I just wanted to get that out there, Mr. Chairman, just so there's no confusion.
Okay, thank you.
Now, with respect to the application that's before the board this evening, this is, as it was read into the record, this is an appeal of a building inspector's decision. In the application, in some of the backup material I submitted, I gave a synopsis as to how we got to where we are. And just to run through it quickly, back about a year ago, maybe a little bit more than a year now, there was a request of the building inspector as to whether the lot in question is a grandfathered buildable lot or not. And I submitted that question to the building inspector along with some research and information that we had. And he eventually, in September of 2019, I believe it was, issued a letter confirming that it was in fact a grandfather lot. The lot in question is about 9,200 square feet. I'm going to say, give or take a little. It's, as I had mentioned earlier, it's a vacant lot of land. The lots themselves were created in a 1906 subdivision plan that was recorded back in 1906, or thereabouts. This is an older area of town. There were quite a bit of smaller lots up in that area. Back at the time, the town of Burlington did not have any zoning bylaws. So the minimum required under the statute to be considered a buildable lot was 5,000 square feet of land and 60 foot of frontage. Our lot had both of those. I hope you can hear me, Mr. Chair. The building department, the building inspector made the finding that it was in fact a grandfather lot because it was created before.
Can you hold on one second? Mark, I think Your speaker is on. Okay,
Okay,
thank you.
great.
Um,
So,
So the building inspector eventually issued an opinion that it was in fact a grandfathered lot because the lot was created prior to the Burlington bylaws being adopted, and therefore it was grandfathered. So with that finding, we eventually went forward to the planning board under the subdivision approval, even though it wasn't technically a subdivision because the land had been created long ago. That's the process by which the planning board deals with requests to build out a paper street. And this lot is frontage is on a paper street at Birch Street. So in any event, we were going through the Board of Appeals, the planning board process that involved having my client retrained to both an engineer and a surveyor to do some plans, do some engineering work. Then I filed the paperwork with the planning board. We had several meetings with the planning board over the course of the summer. And in about September, there was a request made for me to give some more backup as to the argument that this was in fact a grandfathered lot. I submitted that to the planning staff. In a few weeks after that, I was told that town council did not agree that it was a grandfathered lot. And I believe town council was going to speak to the building inspector, and the long and short of it was at the end of September, the building inspector issued a letter changing his opinion, claiming that it was now not a grandfathered lot. Once that ruling was made, we withdrew the planning board application because we couldn't have that application before the board if it wasn't a legal lot. And my client opted to appeal that decision, which is what we did, and we're here tonight on that application for appeal. Just so the board knows, in the event that my client wanted to bring this to the next step, which is frankly to the land court in all likelihood, it's necessary for us to have exhausted all of our local administrative steps before we can go to the court. So obviously, I'm here to answer any questions and make my case for my client, but frankly, I don't come before this board anticipating necessarily that you're going to overturn the town's building inspector and go against the advice of the town council. But it is a necessary step for us to take to proceed to court in the event my client decides to go to court. With respect to the issue itself, there's case law that refers to what they call as the merger doctrine. Once two adjacent non-conforming parcels become under common ownership, they merge into one, and they lose their grandfather status. I believe that is the case that the building inspector is relying on in making the finding that this is in fact not a grandfathered lot, because the lot in question was commonly owned with the adjacent lot. Mr. Danaher owned both of those lots at one point in time. I've done some research that come up with some case law that I would submit makes a case that has his grandfather. This case law getting into the fact as to whether, at least my interpretation, if one subsized lot is joined in common ownership with an adjacent legal lot, then the merger doctrine does not apply. Mr. Danaher's larger lot at 5 Hillside, or the one that he used to own, is a 22,000 plus square foot lot. It's a legal lot. It's been there since the house has been there since 1934. So that was the abutting lot that Mr. Danaher owned at the time he took title to the smaller non-conforming lot. So in any event, Mr. Chairman, frankly, it's a legal argument to be made, and probably the proper forum to make this type of an argument is before the land court. So I'm happy to answer any questions, express and address any concerns the board might have. But at the end of the day, what we have here is a disagreement between my interpretation of the case law with respect to grandfathering lots and the building inspector's interpretation. And I assume that his interpretation is somewhat weighed heavily by the town council's advice as well. So again, if the proper forum probably to settle this is in court, and before we can get to court, we have to go through this process here.
Okay, thank you, Tom. Just before I go to the members, just a couple of comments on this. So to kind of follow up on Tom's point, the building inspector's decision was written with advice and comment from town council. There isn't a direct document from town council, just so the board members know, but the information within the letter from the building inspector, the denial letter, has been reviewed and commented on and edited from town council. So just so the board knows that. And the other thing is, we have a letter from the planning board that we received that I'm just going to read into the record. So from the planning department, dear Chairman Murray, it is our understanding that the applicant is requesting that the previous determination regarding dimensional relief stated in a letter dated September 5th, 2019 from the Inspector of Buildings be reinstated. The planning board unanimously endorses the second Inspector of Buildings determination letter dated September 30th, 2020, particularly as it pertains to Massachusetts General Laws, Chapter 40A, Section 6, regarding property at 0 Birch Street. The board believes that the project should not be able to continue as the two lots have merged in a common ownership. Further, at the planning board's site visit this past summer, the board encountered a significant number of abutters who were opposed to the project. It is the planning board's opinion that if this appeal were to be granted, it would be non-compliant with Massachusetts general laws and would have a detrimental effect on the neighborhood. The planning board fully supports Inspector Anderson's September 30th, 2020 determination letter. We ask that this application be denied by the Board of Appeals, as it is it is in the public interest to do so. If you have any questions, please feel free to call the planning department at 781-270-1645 or email planning@burlington.org. Signed, Kristen Kasner, Planning Director, Planning Department, Town of Burlington. Okay. Now that that's on the record, comments from the board. Jim, we'll start with you.
So I just want to make sure I understand, Tom. So the combination of 34 and 35 is 9109 square feet. Is that?
That's correct.
Yeah. Okay. And I drove by Birch. So are we talking about the lot? If you're looking at 0 Birch, to the left is a.
Yes. The
Okay.
road makes a pretty steep left-hand turn if you're coming up the hill there. And this lot that we're talking about is kind of right in the elbow of that turn.
Okay.
It's on paper, Birch Street continues straight up the hill. So there's a paper street of Birch Street going from that bend all the way up the hillside. And it's right in that area where the lot that we're talking about is, and the frontage is that part of Birch Street that's a paper street up in that area as well.
Okay. All right. Thank you.
Is that it, Jim? Okay. Mark, comments?
So, Tom, I reviewed your memo, your memo that you submitted here, and my question is, because I looked at, is it Pitzik LLC versus Lipsit? Because it seemed to be on point. And,
Yeah.
Can you just give a little bit more information about that opinion?
I can, Mark, because I agree with you. I do think it's on point. The problem is, I think, at least from my perspective, That's a land court case. It's not an SJC case. It's not an appeals court case. It's essentially a trial court case.
Okay,
So to me, it's evidence as to how the land court judges are interpreting the grandfather statute, how it's affected by the Preston case, which is the one that brought merger back into play. But in that particular case is not an SJC case, so it doesn't have the weight that an SJC decision would have.
okay. So what is the distinction, what is the distinguishing factor for you in terms of how these cases come together? Because the merger doctrine, historically, the cases have gone either way, even with the SJC, right?
Yeah, the way that the statute is written clearly states that as long as the properties weren't jointly owned or in joint ownership at the time that the local zoning ordinance came into effect, then it was grandfathered. The Preston case, which is around a 2000, roughly 2001 case, I believe, said that even though that's what the statute says, the statute didn't specifically exclude the merger doctrine, which is a longstanding legal doctrine. So therefore, the court in the Preston case says merger applies even if the merger occurs after the date that the zoning bylaw came into play. So starting up till 2001, there was just the statute, which was pretty cut and dry. Beginning in 2001, Preston came in with the merger doctrine, and there's been, as you mentioned, there's been different cases over, interpreting that in different ways with different fact patterns fitting in one versus the other. It's not a black and white situation. And to answer your question, what I felt the determining factor was in our particular case is that the larger lot parcel at 5 Hillside is a 22,000 plus square foot lot of land. It's a legal lot of land now. It was certainly a legal lot of land back when it was created in 1934, and it was a legal lot of land when the zoning bylaws came into play in the early 50s. The house has been on that since 1934, so that's a legal lot. The way that I read Preston, it deals with a situation where there were two small lots joined together under joint ownership. They combine. But there's other case law, and the one that you mentioned that the land court is, there's a land court decision where they say that a subsized grandfathered lot, when it comes into common ownership with an adjacent legal lot, the merger doctrine doesn't apply, because the theory behind the merger doctrine is you can take two smaller lots and make them bigger to try to mitigate the how far under the bylaw it is. In a situation where you've got a legal lot already, you can't, that's already a legal lot. That's not gaining any benefit from having a smaller lot adjacent to it. And the smaller lot that's adjacent to it, you can't be taking land from a legal lot, because then you would be making that land illegal or non-conforming. So therefore, it wasn't a situation where you could take land from one to make the other one make the other one conform. So again, there are cases all over the place with this, but to me, the way that I read the case law, and I look at some of the land court cases over the last 5 or 10 years, which gives me an indication as to how the land court judges interpret that. I don't feel that the merger doctrine applies, but I'm not going to sit here and say that's an open and shut case either. It's a gray area, like much of the law is. And anytime you start going to court, who knows what'll happen, but that's the way that I read it.
All right, thank you, Tom. I do, I haven't looked at this long, and it's taken you a lot of study to get to where you are now. But to me, the Preston case is two non-conforming substandard lots. That's not what this is. So
I agree.
I think it falls outside of Preston merger doctrine. So just my my sense of the cases. So I'll defer to all the other members for their opinions.
Okay, thank you, Mark. John, comments?
Yeah, a couple of comments. First of all, thanks, Tom, for being so open with the discussion, because I'm going to be more comfortable voting for it to let it go to court, because I agree with you. It probably should go to court because it's such a legal thing. And Mark, I appreciate your information there too, but I don't know enough about the legals of that. So I think it's a good idea that we do take it to court. But I did want to ask, Tom, if even if this was overturned, they would still have to come back before this board because it only has 90 foot of frontage, correct?
If,
All right, so,
if the finding is made by the building inspector that it is a grandfathered lot, or if this board overturns the building inspector's current opinion, which says it isn't, and therefore makes it a grandfathered lot, then it doesn't have to come before this board for variance, because if it's a grandfathered lot, it's a legal lot and you can build on it. What I suspect would happen is that there would be some appeal from the town side. So, but that's
Yeah.
out of my control. But no, to answer your question, John, if it's a grandfather lot, it's a legal buildable lot. That's why this didn't come before you folks back last year, because once it's deemed grandfather, we don't need a variance because the grandfather lot is a legal lot. Had the building inspector back in September of 2019 made a ruling that it wasn't a legal lot, then it's in all likelihood we probably would have come to this board requesting a variance, and then we would have seen how that played out. But once it was deemed grandfathered, it's a legal lot, and we started to go down the planning board route.
well, so I'm still kind of confused, because even though it's a legal lot, wouldn't the builder still have to build within the zoning setbacks? And
the grandfather, the statute says a lot or a building on a lot that's grandfathered is not subject to any of the zoning bylaws that come in after the fact, both in terms of square footage, setbacks, frontage, things of that nature. We're limited to what the zoning was at the time that the lot was created. In our case, there was no zoning, but
okay,
so
you're saying that if this went through, then they have no zoning requirements? They can do whatever they want?
as far
Side,
as
front, back?
as far as setbacks and I mean, obviously they couldn't use it for something other than residential or something like
Yeah.
that, but from a setback and area, frontage, those types of things, they would not.
Oh, yeah, well, that's good enough for me then. Yeah. One other question, and this is just curiosity for me. If this was granted, would that paper street then be brought all the way through, or is it just really going to be like a driveway?
Well, that essentially is what until this came up with the question about whether it's actually legal or not, the planning board process that we were working our way through, that was the goal or the function of that process was to figure out how much of Birch Street had to be built out to provide sufficient access to this particular house or lot. So clearly we wouldn't have had to go all the way up the hillside, because then, we'd going 300 feet past the lot. But there would have been a question, frankly, we were proposing essentially just a driveway to minimize the disruption to the area.
Okay.
But the planning board could have required a full-blown 24-foot street, or they could have agreed to something less than that. But we didn't get to that part of the discussion, certainly that part of the decision-making, because in the meantime, the lot was changed from grandfathered to non-grandfathered.
Okay. Thanks, Tom. Thank you, Chairman.
Thank you. Joe, comments?
No, I do not have any comments. Tom just answered mine about the extension of the road. That was going to be my question. Thank you.
All right, Adam?
No new questions at the moment. Most of mine have been asked already.
Okay, thank you. Yeah, I don't really have anything overly new. I mean, I agree that there's potentially that this potentially could be a grandfather lot because of the wording of the law with the two non-conforming lots, and one of these lots is conforming, but I don't know that this board is gonna, have we're not really gonna set case law or anything on that type of thing. So that's kind of where I'm at with this right now. But this is a public hearing, so I will open this up to the public. I'll ask that people just, try to speak one at a time. I'll give everyone a chance to speak. And again, if everyone, could just, when you're not speaking, leave your microphone muted so that we can hear the person that's trying to speak. So if there's anyone from the public that would like to speak on this, please speak up and let us know your name for the record.
Mr. Chairman, I'll start. Attorney James Giuliano, with Scafidi Giuliano, 42 Pleasant Street in Woburn, representing a few of the neighbors in the area. Respectfully, Attorney Murphy he's right. I mean, this is something that is, I mean, dealing with myself in other cases and other municipalities, it's a tough one. Obviously, we do think that a merger has existed in this case. There is several law that the building inspector has brought out. There's other case law other than Preston. There's Adamowitz versus Ipswich, Cheer Coffee versus Bill Ricca that would imply that this would be a merger. Just as far as a little history of the lots, because I think that's important. Mr. Warren Reed owned the subject property from 1949 to 1985, sold to the applicant in 1985. Lots 36 to 42, which is the 22,000 square foot parcel, that was owned by Mr. Reed as well from 1944 to 1973 and sold to Mr. Danaher in 1973. So Warren owned both parcels for a long period of time, as did Mr. Danaher, who was the applicant. So I think we doubled up on the merger in that case. In cases like this, we always look for, what does town council say to this, because that's probably the best person to speak on matters like this. And I think, which I didn't know, that town council actually had an input in the building inspector's decision. So obviously that would just infer to me that decision that the building inspector has made has some teeth behind it, where town council has input with that. Additionally, as Mr. Attorney Murphy mentioned, despite it, for argument's sake, let's say that, for all intents and purposes, we say that this is a buildable lot. It's still not a buildable lot unless it has one key component, which is frontage, right? So a lot has to have frontage, and in order to do that, the applicant would have to go to planning board, which we understand what happened with the planning board. He would have to go through subdivision control laws at that point. So even if we get past this merger, it's still not a buildable lot per se in its existing state, because it doesn't have frontage on a roadway. This is a paper street, so obviously it has to be improved through subdivision control laws. So I think something like this, where there's a lot going on, should be, in the courts, in the hands of the court, and sort of lean heavy on town council and on the building inspector. So that's, without beating a dead horse, I think Attorney Murphy mentioned the other thing. This is certainly not an easy decision, but again, to emphasize it, not a decision that a Board of Appeal should be making at this point in time. So that's all I have to say on that.
Okay, thank you. Is there anyone else in the public that would like to speak on this matter? I'm just giving it a minute just to make sure everyone has a chance. Okay, I am not hearing.
Excuse me. Hello. This is Bill Lisano. I'm one of the abutters to the property.
Okay,
Yeah, I live at 2 Birch Street, and I just want to, my input would be that I strongly oppose to this project going forward for various reasons that I have spoke about before with the planning board. I had suggested through the attorney that there was a site visit. Everybody came out, looked at the site, and I would strongly suggest that with the Board of Appeals here. The wooded lot that we speak about is right next to my property. The proposed plot plan is putting the house pretty close to my house, along with a couple of the abutters. And as Attorney Murphy had stated, the paper road does go from Birch Street to Hillside. My biggest issue is why we have to go in from Birch Street if it is approved. Once again, I strongly oppose a house going in there, regardless of which way it comes in. My understanding is this paper road runs right through Mr. Danaher's property on Hillside, but it appears to me that he has a fence on the paper road now. I wouldn't be surprised if the addition that he put on a few years ago is actually on the paper road. So I think it's just convenient for him to go through Birch Street, which will highly impact my piece of property. I've been here for over 30 years. I've maintained my piece of the paper road, if you will, in the corner of my property. And once again, I just want to state that I strongly oppose this project going forward. Thank you.
Okay, thank you. Again, is there anyone else in the public that would like to comment?
Yes, Mr. Chairman. My name is Mike Farrow. I reside at 4 Sycamore Street, and Attorney Giuliano represents myself as well as several of the other members. I wrote a pretty detailed memo to the planning board when this process started. I'm not sure if your board has received all the documentation that the planning board reviewed, but there are also a pretty extensive list of neighbors that signed a petition in opposition of the property being developed. I believe the site review that Mr. Lisano just referred to verified in the minds of the members of the planning board that this is not the type of property that should be developed and not in the best interest of the neighborhood and frankly the town. So I respectfully submit that this should not move forward. Thank you.
Okay, thank you. Anyone else from the public that would like to comment on this matter?
Yes, I'd like to say something.
Please introduce yourself.
I'm Katie McDonald. I am Jim Danaher's granddaughter, the one that will be building on the lot. I know Bill Lisano mentioned that he's been maintaining his corner of the paper street. Actually, his property doesn't touch the street. He has come across the entrance of our property with a stone wall, which I think was just supporting what Mr. Hannafin had done, so that he wouldn't get water after the illegal, modifications that he made to his land. Also, we were notified by several neighbors that Mike Farrow approached them with several documents to sign that petition. They stated that they called the planning board to say that they would like their names removed from that petition because they were highly misled about the project. He told them that the property was going to be sold to Litchfield Construction, which that isn't the case. It would actually be my property, my home for my family. And I actually grew up on 5 Hillside. My sister owns the property now. So I just wanted to make a couple of those things clear.
Okay,
Mr. Chairman,
thank you.
just in response to that, this is Mike Farrow again. If you look at the petition, there is no reference to any developer building that property, nor was that stated verbally. So what Katie just said is completely inaccurate.
Okay, we've heard from both, so I don't want to get into a debate about that. We've heard both comments now. Just for clarification on this too, just so that everyone understands what we're looking at, where we as the Board of Appeals are not looking at how this lot would be accessed if it was granted buildable status. Where the access would be that's a planning board issue, which they can't even address until this lot is resolved one way or the other, whether it has buildable status or not. So I just wanted everyone to understand that that's what we're looking at. And so, the existing conditions down there and where a road may or may not go, that would be a planning board issue, which we're not even to that level yet. We're just here to decide whether we think that the building inspector is wrong in his decision, or whether this is a building, or if we agree with him, whether it's a buildable lot or not, and or whether we agree with him. So I just wanted to clarify that so everyone understands. I will again put this out to the public. If anyone would like to make any comments, please speak up. Okay, hearing none, I will put it back to the board. If we, does anyone have any further discussion that we'd like to make prior to closing? Okay, hearing no further discussion, I will put it out to the board for a motion to close.
I'll make a motion to close.
Second.
All right, motion is made and seconded to close the public hearing. I'm gonna do a roll call vote. Adam is voting on this one. So we'll start with Jim,
Aye.
Mark,
Aye.
okay, John,
Aye.
Adam,
Aye.
and I vote aye. All right, the public part of the hearing is closed. All right, any other additional comments from the board or comments on a direction to proceed?
I'll make a comment. I think that we should listen to all the attorneys here that are speaking, and we should deny this project.
Yeah, I would tend to agree with that. I know attorney Murphy commented on some case law which could apply to this lot, and I know attorney Giuliano mentioned some other cases. I don't think at this level of the Board of Appeals is we're going to get into analyzing the different case law that's associated with this type of a merger. So I think the appropriate level to do that would be at the land court. So I would agree that I think, in my opinion, that at this level we would be upholding what the building inspector and town council have put before us. Does anyone else have any questions or comments, or we could take a motion?
I'll make a motion to deny.
Second.
Okay, this is our first one of these, so I'm just looking at to make sure the deny is the right language that we want. Yeah, to deny the reversal. Yeah, okay. All right, the motion is made and seconded to deny the reversal of the request for the reversal of the building inspector's opinion for map number 31, parcel number 53-0. So we'll do a roll call vote. Jim,
Aye.
Mark,
Aye.
John,
Aye.
Adam,
Aye.
and I vote aye. All right, 5-0. All right, thank you everyone for commenting and bearing with us through the virtual meeting.
Thank you, Mr. Chairman. Thank you, members of the board.
Thank you.
Have a good night.
You too. Thank you. Okay. The next item on our agenda is just the minutes from our previous meeting, which I will abstain from because I wasn't there. Not that it's a very long minutes. So anyone that wants to make a motion.
Make a motion to approve the minutes of December 1st, 2020.
Second.
Motion is made and seconded. Roll call vote. Jim,
Aye.
Mark,
Aye.
John,
Aye.
Adam,
Aye.
Joe.
Aye.
Okay, and that's it. I'll take a motion to adjourn.
Motion to adjourn.
Second.
Second.
Motion is made and seconded to adjourn. I guess I got to do another roll call vote. Jim,
Aye.
Mark,
Aye.
John,
Aye.
Adam,
Aye.
Joe,
Aye.
and I vote aye. I don't know if that's too many, but 5-0. All right, that's it. And so I don't know if everyone was on when Joel and I were speaking earlier. Our next meeting is January 5th. As of right now, we have no applications. Applications could come in between now and next Tuesday to be on for that meeting. So Joellen will let us know. If not, it'll be January 19th. So everyone have a happy and safe holiday.
Two.
Yeah, you as well. Mike, I had